Hello. We are going to discuss some recent law updates. So in a previous video, when we were looking at the Professional Licensing Bureau, plb.iowa.gov, I had shown you under that real estate section where you could go to look up the Iowa Code and the administrative rules. And in that section, we had a law update little bit that had the year and whether the code or the administrative rules had changed. So we'd have several changes, and it looks like we went about 3 years, I believe it was, without any changes. And then in 2017, moving forward, we have had some significant changes. And I just want to highlight a few of these things for you. Now, for the most part in 2017, if you're new to the business, you probably have learned these as you went through pre-license. If you're renewing now, you probably learned about them the last time you took a law update class, but I do think there's still some worth in reviewing these. I have noticed that there are several things that they did in that updating of codes that was actually just a cleanup. So correcting some language to maybe take out banking terms from savings and loan to FDIC and credit unions for banks, where you might have your trust account, for example. So let's dive into these that I think will be most important for you. And the first one is that there is no physical license that needs to be hung on your broker's wall anymore. Back in the day, you might remember there was that famous cork board, and all of our little licenses were hung up there. And we tried to keep them in alphabetical order, and someone would join it, and we had to rearrange all of them. Some of you maybe, but we had to make it obvious to the world that you were licensed at that brokerage. And we've changed. Everything is now stored online. So again, if you iowa.gov website, you can that is, you think licensed, and see whether they are active, inactive, expired. And then you can also see exactly what brokerage they currently hang their license at. The next one is the 3 violations in 3 years rule. Prior to 2017, you were allowed up to 5 violations in a 3-year renewal period before they would revoke or suspend your license. They have brought that down now to 3 violations in 3 years. Now, I don't think any of you are out there getting in this much trouble, but there may be a few of you that have walked the line a little bit and hopefully are on the better path to getting it figured out. However, the reason I point this out is this also includes your broker, which means anytime you as a salesperson or a broker associate gets a violation, the commission could look at that complaint, or again, if they do decide to cite you a violation, they may look at that and think, the complaint wasn't specifically filed against the broker or the brokerage. However, they were in charge of your supervision. They're ultimately in charge of your supervision. They can't use the excuse of hear no evil, see no evil, speak no evil. Even if they don't know about it, they're still accountable for you, which means, again, even if they weren't part of that complaint, the commission could go back and say, where was this broker? Where were they? Why weren't they helping out? And if that's the case, they may take a look at also putting a violation on your broker. Now, some of you have brokers and some of you are brokers that manage multiple agents, maybe anywhere from 2 or 3 yourself, but 2 or 3 to several hundred. There's some big brokerages in Iowa. So the risk is every time that we have you as a salesperson creating violations, it puts your broker's license at risk as well. And I know we all appreciate the hard work that our brokers do for us. So just keep in mind, these violations are not just a reflection of your behavior, but your brokers as well. Next up is one broker can manage multiple offices. I am not entirely sure what created this law change. Yet I do think it opens up some interesting opportunities for the fact that we can now have one broker manage all of their offices in this state. And if the offices are separate brokerages or separate entities, then that rule doesn't apply. But anytime we've got one brokerage and that entity literally has different locations all over the state of Iowa, we can just have one broker cover all of those agents. For you as broker, if you're looking to franchise, so to speak, or have different locations throughout the state, maybe you've got a good thing going in central Iowa, but a cousin gets licensed in the Quad Cities area and would like to be a part of your systems and organization and kind of team with you. That opens up a great opportunity. I know as we have franchises opening and being created, that might be an option as well. It does also help, I guess, spread kind of the workload as well, considering maybe not all brokers are created equal. And maybe as we have these different franchises, we were having a hard time finding a broker at each and every one of them. I'm not sure what it is the Iowa Real Estate Commission can assess a civil penalty to a non-licensed person. So what does that mean? That means that before we used to have civil penalties just for those who had an active real estate license or had a license. And the civil penalty that you can get is up to $2,500 per violation. This now addresses someone who is not licensed at all. So where I've seen this happen, and I'm not going to call any names out, of course, I believe was a builder who maybe gave the impression to someone wanting to build a home that he knew the value of their property. And maybe he was taking that property on trade to build the new home and said, for example, I'll give you $350,000 for it. Then built the house. And when they sold, when that that builder sold the home, he sold it for $450,000 and created a nice big profit for himself. Those clients then went back and said, wait a minute. We sold it at $350,000 because we thought that was the true value. We thought as a builder, you presented yourself as someone who knew a lot about the market, basically for a wholesale price. This is where I can see an example of that. But I also do want to caution anyone out there who you see that might be wanting to play real estate because HGTV or whatever makes it look so easy. I don't know. I know I've seen a few for sale by owners where they're maybe having a friend that just loves real estate, help them with the showings and some things like that. That's a very fine line. I would be very careful with that because the fines on this could result up to 10% or of the sales price or a $10,000 fine, whichever is greater. Again, $10,000 or 10% of the purchase price could be a punishment for that, which could be very, very hefty, of course. Next is personal funds from the broker can be $1,000 in the trust account. So typically the law is when it comes to an escrow account, and a trust account is a type of escrow account, we are not allowed to have any personal funds in that account. That is other people's money. It is protected and audited so that it does not commingle with the broker's general funds where we pay commissions, salaries, the printer rental, all of those details. We don't want that escrow and that general fund to ever meet. Again, it's called commingling, highly illegal. And we also have a trust account auditor that will come and find that, and you will get subject to all of these violations and fines we've been talking about. However, there is an exception to the rule. The broker is allowed to keep first personal funds in that trust account just to cover bank expenses. The law used to say $500, and now the law, as of, I believe, July 2017, July 2017, I believe I know the law now has changed to 1,000. Sorry. So it was 500, now 1,000. And the reason that we're allowed to, by law, keep that money in there is, again, just to cover bank fees. We're able to maintain that in there because there's usually some sort of a business account fee that the bank charges. And if anything, we can't open a trust account up. We can't open an account up with $0. So that is an update as well. Next up, we have the electronic presentation of the seller's disclosure. So prior to 2017, be honest, did you ever electronically send a seller disclosure to anyone, particularly your buyers? Yeah, we've been having those e-signed, I know, for a very, very long time, and the code finally kept up with us. So if you've been doing that wrong, no worries. You've been doing it correctly since 2017, so that's good news. Next is the listing agent does not need a buyer agency form. This is another one. How many of you used to take your buyer appointed agency form and give a copy of it with the offer to the listing agent? I think that's one we were skipping, correct? So if you do not send that buyer agency agreement along with your offer to the listing agent or as part of turning in the sale, you are now following the law. And if you hadn't been doing it for a while, I think you're in good company. In fact, I used to get a copy of a buyer agency form and think, why did they send me all this extra paperwork? What were they thinking? Well, they were thinking the right thing because they were following the law. So again, those buyer agency forms, I don't think that was very well practiced. But again, you don't need to worry about it now. This is a big one for us that happened in, I believe, January of 2018. We've got two types of classes that when you're renewing your license or you're taking license pre-broker courses, there's two categories that has. One is a live course, and that was always where you came to a classroom, you sat down with an instructor, we're all together in one room. The second option was what they call distance learning. You and I probably call it online learning, where you hop on a course, it's self-paced, there's no live instructor. So by law, the two definitions were live and distance. Well, now we've got this word online that the code exactly hasn't kept up with, but they did change the law to include a live course to be considered as any platform where the student and instructor can see and hear each other in real time. So now a platform like Zoom is considered a live course because we can see and hear each other in real time. Now, I think Zoom is maybe the popular platform. If you're watching this video in the future, there may be something more brilliant out there. But that's kind of the example that we're working with right now. So been a great experience as we've gone through COVID in 2020 and 21 and possibly beyond. However, what you're doing with an instructor on Zoom is considered live. Now, just as an example, this is why it's important. The code says you need 36 hours to renew your license, which I'm sure is what you're working on right now, correct? 8 of it must be law update. 4 of it must be ethics, and 24 of them must be electives. The law also goes on to say that of those 36 live, the other 24 can be done distance learning. So live with an instructor is going to be actually in a classroom or on a platform, but it's really called doing self-study with an approved program. Are we clear on that? That's kind of a fun one because now you can get live credit hours and be in your footy jammies if you've got an instructor that's doing Zoom. Broker course requirements were reduced. from 72 hours to 60. This happened in January of 2020 is when it became official. We used to need to have 72 continuing education hours of approved pre-broker courses. Now they have brought that down to 60 hours. Again, all of the courses need to be completed within 24 months, and you need to have been actively selling real estate for 24 months prior to the application. So this saves you a little bit of time now as well. One other quick note, and this isn't really a law change per se, but they did add remote PSI testing as of the fall of 2021. So I wanted to throw that in there because if you're considering getting your broker's license, you do need to go and take the broker exam. PSI Exams is the name of the company that the Real Estate Commission has authorized to proctor those exams for us here in Iowa. Always you had to go to a location, either in Cedar Rapids, Des Moines, or Council Bluffs, and register for your exam. Great. Now they offer testing at home. So if you're somewhere where you don't have those locations convenient, or you just simply don't like to travel, you now have a remote option. Now, I will say, this sounds very convenient, and I think that it is. However, it will include specific software that you've got to download. That software prevents you from being able to Google answers or check your email or go and search things. They will require you to do some sort of a room scan to make sure that there's no electronics, including printers and fax machines, Apple Watches, no food and drink, and someone will watch you take the exam, which means if you're saying test answers out loud, someone's probably going to wonder if maybe you're trying to shout through the door and get some help. So it is heavily regulated. But again, for you, whether you're doing pre-broker or you know of someone looking to do pre-license and get in the business, this could be a great solution so that folks don't have to drive to maybe 2 and 3 hours to a test center. I know some of my folks that get licensed in the Sioux City area, they got to get a hotel in order to get there early enough in the morning. This could save a lot of that. Plus, it's Iowa, and we've got weather here, right? So it could maybe save some of those travels. The last update that we probably have seen is that anyone that's got a living trust must fill out the seller disclosure. The law used to say that anyone, if it was in a trust, they were exempt from filling out the seller disclosure. Well, the problem is, we had some revocable trusts that were maybe set up and the individual had now passed away. And then we had some trusts that was just like a regular seller selling their home, moving somewhere new. So we have these trusts out there where maybe some of them have passed away and some haven't. If they passed away, the executor of their estate is exempt from filling out the seller disclosure. But the person that's still alive, they still have knowledge about the condition of the property. They are now required to fill out the seller disclosure. So that blanket trust rule that was out there, not needing to fill out the seller disclosure, that has gone away. Obviously, the executor of an estate, and maybe the estate was already set up into some sort of a trust, that executor is exempt. But if the person is still alive selling their own property, they now must fill out the seller disclosure in its entirety. For more information on that, there is a great video with the Iowa Association of Realtors. Again, go under the legal tab at iowarealtors.com, and there's several legal breakdown videos on there, and there's an extended remix of this one that might help you out too. That's our review of law updates. Hope that was super, super helpful. And we are on to the next chapter.